You warned them. They didn't listen. My stepmother said my father died with nothing. But 3 days after his funeral, she was already trying to make me sign away an estate I had never been allowed to see. The question was simple. What was she so desperate to close before I found out what my father had left behind? My name is Claire Bennett. I was 34 when my father, David, died in Oregon. I worked in payroll for a regional medical supplier, rented a small townhouse outside Portland, and had never considered myself the kind of person who would end up in probate court fighting her own family. My father and I had never been especially close after he married Elaine. We were not enemies. We exchanged birthday texts, spoke on the phone every few weeks, and met for lunch when schedules allowed. But after the marriage, Elaine gradually became the person who answered his phone, organized his appointments, handled his mail, and explained what he supposedly meant. I accepted that arrangement because it was easier than arguing. That was my first mistake. When Dad died, Elaine called me before the hospital did. Her voice was calm, almost businesslike. She told me there would be a small funeral, that his debts had taken nearly everything, and that she wanted to keep the paperwork simple. She used that phrase twice. Keep the paperwork simple. At the funeral, Elaine stood beside my half-brother, Mark, and spoke about how difficult the last year had been. Mark handled the flowers, the guest book, and the phone calls. I was grateful at first. Grief makes ordinary tasks feel impossible, and they seemed prepared. Then, before the burial was even over, Elaine asked me for my mailing address. Not because she wanted to send photographs, not because she wanted to stay in touch. She said the estate attorney needed it. When I asked which attorney, she looked at Mark before answering. The one handling the house. That was the first detail that did not fit. My father owned a modest house in Beaverton. He had bought it years before the marriage, and I knew he had refinanced once. I did not know the balance, the value, or whether Elaine had any separate claim to it. But if an attorney was handling the estate, there should have been a case number, a notice, or at least a name. Elaine said she would send everything later. She never did. Instead, she sent me a one-page statement titled, Family Understanding. It said that Dad had no significant assets beyond household belongings, that Elaine would remain in the home, and that I would not make claims against the property. There was no court heading, no attorney letterhead, no inventory, no signature from my father. At the bottom, Elaine had written, Please sign so we can all move forward. I almost signed it. I was tired. I was grieving. And I believed the people who had been physically closest to my father during his illness knew more than I did. Then I noticed the date. The document was dated 2 days before my father died. That did not prove anything. People prepare estate paperwork before death. But the wording bothered me. It did not describe a will. It described an agreement between living relatives, including one person who had not agreed to anything. I asked Elaine what it meant. Her reply came within a minute. It means there is nothing for you to worry about. That answer created the next question. If there was nothing, why did she need my signature? I did not confront her. Not yet. I told myself I would wait until the funeral expenses were settled. I told myself grief had made me suspicious. I told myself family members sometimes use clumsy language when they are overwhelmed. Those explanations lasted 4 days. On the 5th day, I went to my father's house to collect a box of old photographs. Elaine had agreed to let me come, while she and Mark were out. The house felt unfamiliar. Furniture had been moved. Several shelves were empty. The desk in Dad's office had been cleared except for a lamp and a stack of junk mail. I found the photographs in the garage. I also found a shredder running in the office. No one was there. The machine was warm. Inside the wastebasket were strips of paper with pieces of bank logos, account numbers, and a return address from a financial institution I did not recognize. The pieces were too small to reconstruct, but one strip showed the last 4 digits of an account. I took a picture. That was the first clue I could prove existed. When Elaine came home, I asked whether Dad had kept an investment account. She did not look surprised. She looked annoyed. Your father had ordinary checking, she said. There was no hidden money. I asked why his bank paper S had been shredded. She said she had been cleaning. Mark stepped between us. He was 31, broad-shouldered, and usually quiet around me. This time he was not quiet. He said I was turning a death into a financial investigation and that Elaine had done everything for Dad while I lived my separate life. That accusation landed because part of it was true. I had lived my separate life. But being absent from daily caregiving did not mean I had surrendered my rights as an heir. I left with the photographs and the image of the account fragment. That night, I searched public probate records. I did not find a completed estate. I did not find a filed will. I did not find an attorney connected to the house. I did find a case opened under my father's name. The filing date was the morning after the funeral. The petitioner was Elaine. The listed assets were the residence, one vehicle, household goods, and a checking account. The estimated value of the estate was far below what I expected from the house alone. The property had recently sold in a comparable listing for more than $500,000. The filing listed the house at a value just under $300,000. Maybe the number reflected the mortgage. Maybe the property required repairs. Maybe I was missing something. But the filing also said there were no known additional financial accounts. I stared at that sentence for a long time. No known additional accounts. It was carefully written. It did not say no additional accounts existed. It said Elaine did not know about them. The next morning, Elaine called and asked whether I had looked up the probate case. I had not told her that I had. That was when I understood that she was monitoring what I did. She said the court process was routine and that hiring a lawyer would only waste money. Then she offered me $3,000 to sign a family settlement and stop asking questions. $3,000. She called it a gesture of fairness. I asked whether it came from the estate. She said it came from her personal savings. That sounded generous until I remembered the house. Why would someone pay me to waive claims against an estate that supposedly contained almost nothing? I declined. Elaine went silent. Mark sent me a text an hour later. "You are making this ugly." The message had one attachment, a photograph of my father's empty office. The desk was gone. I had seen that desk 4 days earlier. I asked where it went. Mark did not answer. Instead, he wrote, "You should have taken what was offered." That was the second clue. The offer was not generosity. It was a deadline. I contacted an Oregon probate attorney named Rachel Alvarez. In this adaptation, Rachel is a fictional attorney, and the specific legal details are included for storytelling rather than legal advice. She reviewed the public filing, the settlement document, and my photograph of the shredded papers. Her first question was not how much money I thought my father had. It was, "Did you receive formal notice of the probate case?" I said no. Her second question was whether Elaine had shown me the will. I said Elaine claimed there was no will that gave me anything. Rachel paused. "Those are different statements," she said. "A person can die without a will. A person can also have a will that another family member refuses to produce. In probate, the court generally needs to determine which situation actually exists." Rachel told me not to sign anything else. She filed a request for the estate inventory and asked the court to require Elaine to account for financial records. 3 days later, Elaine's attorney sent a letter accusing me of harassment. The letter said my father had intended for Elaine to inherit everything. It said he had discussed this privately with Mark and that I had no legitimate reason to interfere. There was still no will attached. That omission changed my view of the entire dispute. If the will clearly favored Elaine, why not show it? Rachel said the answer could be simple. The document might not exist, might be difficult to authenticate, or might say something different from what Elaine claimed. Then she asked me to search through everything I had from my father. I opened old birthday cards, scanned photographs, and checked the small number of emails he had sent me. Most were ordinary: weather, work, a joke about airport security, a reminder that he had found an old family recipe. One email, sent 8 months before his death, ended with a strange line: "When the time comes, check the blue folder before you trust anybody's summary." I had assumed the blue folder was a reference to medical paperwork. Dad kept documents in colored folders. I looked through my apartment and found nothing. Then I remembered the garage at his house. The blue folder had been behind a box of holiday decorations. It contained copies of tax returns, an old mortgage statement, and a business letter from a credit union. The letter referred to a trust account. The account was not labeled with Dad's name in the way I expected. It was connected to a living trust created years earlier. The beneficiary page was missing. I sent a scan to Rachel. She called me that evening. "Your father may have had an asset that was not listed in the probate petition," she said. "May have." That cautious phrase was frustrating, but it also meant the case had moved from suspicion to evidence. The credit union could not speak to me directly. I was not yet recognized as the personal representative. Rachel sent a formal request. The institution confirmed that David Bennett had maintained an account connected to a trust and that the account had been closed shortly after his death. The balance had been transferred. The recipient was not Elaine. It was Mark. The amount was $186,400. For several seconds, I could not understand the number. Mark had told me the estate was insolvent. Elaine had offered me $3,000. The probate filing had listed no additional account, but the account had existed. It had contained nearly $200,000, and Mark had received it after Dad died. I asked Rachel whether that automatically meant fraud. She said no. A trust account can pass outside probate if the documents are valid. A beneficiary can receive money legally. The central questions were whether the transfer followed Dad's instructions and whether the account had been disclosed accurately. The next morning, Mark deposited a cashier's check for the same amount into a new account. That detail came from a bank record Rachel obtained through the court process. He had moved the money after learning that I had hired counsel. Why move it again? Because someone expected the court to ask where it went. Rachel filed an emergency request to preserve the funds. The court ordered Mark not to transfer or spend the disputed amount while the case was pending. Elaine responded with a sworn declaration. She said my father had given Mark the money during his lifetime as help with a business venture. She said the transfer after death was merely administrative. She also said the blue folder had been planted in the garage by me. That last claim was absurd, but it mattered because it showed what they were willing to say under oath. Rachel asked me whether I had ever seen Dad discuss Mark's business. I had. Dad occasionally complained that Mark borrowed money and avoided repayment. I had no records proving it, so I did not treat that as evidence-y. But I remembered something else. Dad had once told me, Mark thinks the money is his because he has seen the account, but he has not seen the instructions. At the time, I thought Dad was talking about a college fund. I wrote the sentence down. Rachel asked me to search my phone backups for old voice messages. I found one from Dad, recorded 2 weeks before he died. He sounded tired but alert. He said, Claire, I need you to understand that silence is not the same as consent. If Elaine says I changed everything, ask to see the original. That was the third clue. My father knew Elaine might make that claim. The voice message did not identify a will, but it gave us a reason to investigate one. Rachel subpoenaed the attorney listed on an old trust document. The attorney had retired, and the firm had transferred old files to a storage company. The paper file contained a draft will, a trust amendment, and a letter from my father requesting that the final documents be held until a video appointment could be completed. The final signed will was not in the box. The draft divided the estate between Elaine and me. The trust amendment directed that Mark's access to the account would be limited until he repaid certain debts. A handwritten note in the margin said final instructions to be recorded. Elaine's attorney argued that drafts were not valid wills. He was right about that much. Rachel said the documents did not yet win the case. They showed intent, not final execution. We still needed the missing will or another legally acceptable proof of my father's final wishes. Then the case took a stranger turn. The retired attorney's former assistant remembered a package sent to my father's home. The package contained a password-protected video file on a USB drive. The assistant did not know whether the file had been delivered. She did know the delivery required a signature. The signature belonged to Elaine. Elaine denied receiving any package. The shipping company produced a delivery record. The package had been delivered 6 days before Dad died. The signature was not perfectly clear, but it resembled Elaine's name on the probate filing. Mark claimed the package contained medical records. Elaine said it might have been a birthday gift. Neither explanation matched the attorney's description. Rachel asked the court to order Elaine to search the house and produce the device if she had it. The judge gave her 10 days. On day 9, Elaine's attorney announced that a USB drive had been found in a locked cabinet. The file was encrypted. Elaine said she did not know the password. Mark said he had never seen it. I believed them for about 6 hours. Then Rachel received a message from the retired assistant. She had remembered one more detail. During the video appointment, my father had used a phrase as the password, the name of the diner where he and I had eaten on the night he told me he was proud of me. I knew the phrase. It was not a secret between my father and me. It was just a small memory I had never mentioned to Elaine or Mark. The password opened the file. The video began with Dad sitting at his desk. He looked thinner than he had at Christmas, but his voice was steady. He explained that he had created the video because he believed someone might hide or misrepresent his final documents. He said Elaine had access to the household mail. He said Mark knew about the trust account. He said he wanted both of them to understand that access was not ownership. Then he looked directly into the camera. "Claire," he said, "if you are watching this, do not assume I stayed silent because I forgot you. I stayed quiet because I wanted to finish the paperwork without starting a fight I might not live to see resolved." The video included dates, account instructions, and the location of the original signed will. It was inside a safety deposit box at the credit union. The beneficiary of the trust account was not Mark. The account was intended to fund repairs and taxes on the house, then divide the remaining estate between Elaine and me. Mark had been allowed temporary access only to manage a business debt, and the trust amendment specifically warned that he could not treat the money as his own. Dad had also named an independent successor trustee. That person was not Elaine. It was his longtime accountant, Thomas Reed. The video did not solve every legal question. It did something more important first. It gave the court a clear reason to reopen the investigation. Thomas produced the original trust documents. The credit union produced its records. The retired attorney confirmed the signing appointment. The delivery record connected the video to Elaine's house. The handwriting on the folder and the notes in the attorney's file matched Dad's known records. The missing will was found in the safety deposit box. It was signed and witnessed. It did not leave everything to me. That part matters. The truth was not a secret fantasy in which I received every dollar and Elaine received nothing. The will gave Elaine the right to remain in the house for a limited period and provided her a specific amount for living expenses. It divided the remaining property fairly. It also stated that any beneficiary who concealed estate documents or misappropriated trust funds could be removed from administration and required to return the money. Dad had anticipated the exact behavior that followed his death. The court ruled that Elaine had failed to disclose the trust account and had withheld the will. Mark had accepted and moved funds contrary to the trust instructions. They were removed from control of the estate and ordered to return the disputed money. The phrase, "disqualified from inheritance," was used loosely by people online, but the actual court result was more precise. They lost control of the estate, faced repayment obligations, and forfeited benefits tied to their misconduct under the estate documents and court orders. The final legal consequences depended on the evidence and the jurisdiction. That distinction mattered to me because I did not want a dramatic story. I wanted an accurate record. The house was eventually sold. Elaine received the amount the will provided. The remaining proceeds were divided according to Dad's instructions. The trust account was restored before distribution. Mark's business was not my responsibility, and I did not pursue a personal relationship with him after the case ended. The probate judge referred the suspected concealment to the appropriate authorities. Whether that led to criminal charges was never fully explained to me, so I will not pretend to know more than I do. The civil record was enough to establish what happened to the estate. Elaine accused me of destroying the family. I told her the family had been damaged when they decided the truth belonged to them. That sentence was the closest thing I had to a victory speech, and even then, it did not feel victorious. I had spent months reading statements that described me as greedy, absent, and disloyal. I had learned that people can sound sincere while making claims they know cannot survive a document request. I had also learned that trusting family is not the same as surrendering your judgment. My mistake was not loving my father. My mistake was assuming that love made everyone else honest. The largest clue had been sitting in front of me from the beginning. Elaine did not simply say the estate was small. She rushed me toward a settlement, avoided the word will, and treated my signature as the thing that would make the problem disappear. The second clue was the account fragment in the shredder. The third was Dad's warning that silence was not consent. The final clue was the video, and it changed the meaning of everything before it. The strange urgency at the funeral was not just grief. The family understanding was not just poor wording. The $3,000 offer was not just generosity. Each moment was part of an attempt to close the estate before the original instructions could surface. Would I have discovered the truth without that email? Maybe not. Would I have acted faster if I had trusted my first instincts? Definitely. After the case ended, I kept the video on 2 separate drives and gave a copy to the attorney's office. I also made a written list of my own accounts, beneficiaries, passwords, and instructions. It was not dramatic. It was practical. That is the part people often skip when telling stories like this. A will is not a magic shield. A trust is not invisible armor. Records still need to be found, accounts still need to be disclosed, and the people left behind still need to know where the documents are. My father tried to create that trail. Elaine and Mark tried to erase it. They nearly succeeded because I waited for family members to volunteer the truth. The update is that the estate was closed, the disputed funds were accounted for, and the distribution followed the signed documents. Elaine moved to a smaller rental. Mark repaid part of the money through the estate process, with the remaining obligations handled under the court's order. I have not spoken to either of them in years. I still miss my father. That did not disappear when the money was recovered. Neither did the anger. But the anger eventually became something more useful, a boundary. If someone asks you to sign quickly after a death, slow down. If someone says there is no will, ask whether the court has confirmed that. If the story keeps changing, write down the changes. And if a relative tells you that asking questions makes you disloyal, remember this: questions do not create secrets. They reveal where the secrets are. The last time I watched Dad's video, I noticed something I had missed during the court case. Before he ended the recording, he looked down at a sheet of paper and smiled. He said, "I hope you never need this." Then he added, "But if you do, trust the records more than the explanations." That became the sentence I carried forward. Not because records are cold or families are worthless, because truth should not depend on which relative speaks first, which document gets shredded, or who feels entitled to control the room. My stepmother believed I would accept her summary. My brother believed the money was his because he had touched it. My father left behind a trail that proved neither assumption was true. And in the end, the inheritance I was never supposed to find was not only money, it was the truth about what my father wanted, the courage to challenge the people hiding it, and the knowledge that grief does not require surrender. The open question is what would have happened if I had signed that first page. The court might still have reopened the estate, or I might have waived claims before I knew what they were. I will never know for certain. I only know that the signature would have made their version easier to preserve. The evidence made mine impossible to ignore. Told you so. Told you so. I said it aloud in my kitchen, and for a moment I expected the room to answer. It did not. The refrigerator hummed. Rain tapped against the window. On the counter, beside an unopened envelope from the bank, sat the 2 drives containing my father's video. I had been sorting old files because I was moving. Not across the country, not to a new life in some dramatic sense, just 3 streets away, to a smaller house with better light and fewer rooms that carried memories I had never asked to keep. I'd planned to throw out the envelope without opening it. The return address was from a storage company in the next county. I recognized the name because Dad had used them for a few months after selling his workshop. I assumed it was a final billing notice or a stale advertisement. The probate case had been closed for years. I had no reason to think the company had anything connected to him. Inside was a photocopy of a rental agreement and a typed letter. The letter began, "To the executor or lawful representative of the estate of Daniel Mercer." That alone made me sit down. The storage company explained that an abandoned unit had been opened during an annual audit. The account was listed under my father's name, but the contact information was incomplete. The original contract had been filed under a business number that no longer existed. Several attempts had been made to reach Elaine at the address she had provided during the estate proceedings. The letters came back marked undeliverable. They had found my address through a public probate record. The company wanted instructions within 30 days. A handwritten inventory was attached. It listed 3 plastic bins, a metal filing cabinet, 1 wooden trunk, and miscellaneous personal papers. There was no mention of money, jewelry, or anything that sounded valuable. I almost called the number immediately. Instead, I stared at the phrase, "lawful representative." I was not sure whether I still qualified. The estate had been closed. The trust had been restored. The documents had been distributed. If the storage unit contained property that belonged to Dad, the law might require a new filing. If it contained only old tools and Christmas decorations, I could waste weeks dealing with an abandoned unit over nothing. Then I noticed the date on the rental agreement. The unit had been opened 6 days after Dad died. I read the line again. 6 days. That was before the funeral. Before Elaine called me. Before she told me there was nothing left except bills and a house that needed to be sold. I called the number. A man named Victor answered. He asked for the reference number, then placed me on hold. I could hear a faint recording about late fees and access codes. When he returned, his voice had changed. He sounded more careful. "Are you Mr. Mercer?" Yes. Your father's son? Yes. Do you know whether your stepmother rented a unit under his name? No. There was a pause. I need to ask you something before we schedule access, he said. Was your father involved in any kind of business partnership? Not officially. He had a workshop. He did some contracting. Did he ever mention a man named Mark Mercer? My hand tightened around the phone. Why? Because Mark is listed on the emergency contact section. I stood up so quickly the chair struck the cabinet behind me. Is he listed as an authorized user? No, emergency contact only. Did he ever access the unit? Victor hesitated. According to the log, yes. How many times? I can't release that information until we verify your authority. I'm his son and the estate's beneficiary. I understand. I'm not refusing access. I'm saying we need identification and a copy of the probate order. I looked toward the cabinet where I kept the court documents. I had not opened that folder in years. What happened to the unit? I asked. It was emptied by an unknown person. The room seemed to narrow. When? 5 months after your father's death. Who signed it out? We don't have a signature. The access code was used after business hours, and the gate camera was damaged that week. Then why are you contacting me now? Because the unit was not fully emptied. There's a lock trunk inside, and our staff couldn't open it without damaging it. We held it because the account had not been properly closed. I did not speak. Victor continued. The trunk has your father's initials burned into the lid. DM. I remembered that trunk. It had been in Dad's workshop for as long as I could remember, wedged beneath a workbench and covered with sawdust. When I was a child, I had asked what was inside. He told me it held things that were too important to leave lying around. I assumed he meant tools. Can I come tomorrow? I asked. Victor gave me an appointment for 9 in the morning. I called my attorney before I went. She was older now, working fewer cases, but she still recognized my name. When I explained what had happened, she did not tell me to ignore it. Do not open anything alone, she said. I'm going to a storage unit, not a crime scene. Those are not mutually exclusive. I heard papers moving on her desk. Bring the probate order, your identification, and a witness who has no personal stake in the contents. Photograph the unit before anything is moved. Ask for the access records in writing, and do not contact Mark. I wasn't planning to. Good. If he has already removed property, let him explain that to someone who is not you. The next morning, I asked my friend Claire to come with me. Claire had known Dad casually through me, but she had never been involved in the estate. She agreed after I told her I might need someone to take photographs and keep me from making assumptions. The storage facility sat behind a tire shop and a row of industrial warehouses. Its office had tinted windows and a faded sign promising 24-hour access. Victor met us at the gate with a clipboard. He checked my identification against the probate order, then copied everything. The moment he saw the case number, he frowned. This file was marked closed, he said. It was. So this is a separate asset? I don't know yet. That's what I'm trying to understand. He led us through 2 corridors of metal doors. The air smelled of dust, cardboard, and old insulation. Unit 418 was at the end of a narrow hallway. The padlock had already been cut. A new one had been placed by the company. Victor removed it. The unit was almost empty. A broken lamp lay on its side. There were scraps of packing paper, a torn curtain, 2 empty paint cans, and a rectangle of cleaner concrete where something large had once stood. Along the back wall sat a black metal filing cabinet with 1 drawer hanging open. The wooden trunk was beneath it. I recognized the scratches on the lid before I saw the initials. Claire raised her camera. "Wide shot first," she said. I nodded. Victor stayed near the door while we photographed the walls, the floor, the cabinet, and the true NK from every angle. The cabinet contained only empty folders and a rusted set of keys. One folder had a strip of masking tape on the tab. "Insurance," I said. Inside were photocopies of property records, a receipt from an equipment dealer, and a handwritten note. The note was in Dad's handwriting. "Ask for the ledger before trusting the story." I felt the old anger rise, immediate and physical, not because the note was surprising, but because it showed how deliberately he had prepared for being misunderstood. Claire looked at me. "You okay?" "I don't know." The trunk was locked with a small brass key. Victor said the company had found the key taped beneath the filing cabinet. He had kept it in an envelope. I photographed the envelope before opening it. The key turned easily. Inside were no tools. There were 6 file boxes, a canvas pouch, a sealed glass jar, and a brown envelope with my name written across the front. Not to my son, my name. The handwriting was unmistakable. I did not touch the envelope. "Call your attorney," Claire said. I should open it. "Call first." My AT attorney answered on the second ring. I described the contents and read the label on the envelope. "Is it sealed?" she asked. "Yes." "Is there any reason to believe it contains privileged legal material?" "Not that I know of." "Then photograph the front and back, note the condition, and open it with Claire present. Keep the boxes exactly where they are until we know whether this is a newly discovered estate asset." I did as she instructed. The envelope contained a single letter and a key card. The letter was dated 3 weeks before Dad died. He wrote that he had opened the storage unit because Elaine had started moving documents from his office without telling him. He had seen her remove a folder from the lower desk drawer and take it to the house. When he asked about it, she said she was organizing paperwork. He did not accuse her of stealing. He wrote that he had learned accusations were less useful than dates, receipts, and photographs. The next paragraph made me stop. Mark has been asking about the workshop accounts. He believes the business owes him more than it does. He has also been using the company card for personal expenses. I told him the card would be canceled. Since then, he has become impatient. That was new. During the original case, we had known about Mark's withdrawals from the trust account. We had not known he had been using Dad's workshop card before Dad died. The letter continued. "If they tell you the unit was emptied, do not accept that statement without an inventory. The property removed from here belongs to the estate unless properly transferred. The ledger is in box 4. The account information is not." I looked at the boxes. There was no box 4 visible. Each box had a number written in black marker. 1, 2, 3, 5, 6, and 7. "Where is 4? Claire asked. "I don't know." The canvas pouch contained 3 old keys and a folded receipt from a locksmith. The receipt was dated 2 days before Dad died. The description read, "Duplicate key, private office cabinet." The glass jar held a roll of microfilm. Victor stared at it. "What is that?" he asked. "Something I'm not going to identify by guessing," I said. We took the boxes to a conference room in the facility office and counted every item. Box 1 held workshop invoices. Box 2 contained tax returns and supplier statements. Box 3 held photographs, most of them showing equipment and vehicles. Box 5 contained personal letters, including several from my mother that Dad had never shown me. Box 6 held a thin binder labeled transfers. Box 7 held a small digital recorder. The binder was the most important. It contained copies of checks, purchase orders, and handwritten notes comparing company expenses with personal withdrawals. The entries covered the 18 months before Dad's death. Mark's name appeared repeatedly beside charges for hotel rooms, restaurant bills, fuel, and a motorcycle dealership. At the back of the binder was a signed agreement. It stated that Mark had borrowed money from Dad to purchase equipment for a new business. The amount was not enormous, but it was more than the settlement Elaine had first offered me. The agreement required repayment over 5 years. It also stated that if Mark failed to make payments, the debt could be deducted from any inheritance. There was no evidence that Mark had disclosed the loan during probate. I turned the page. A second agreement showed that Elaine had received a transfer of ownership in a small parcel of land outside town. The transfer was conditional. She could live on the property, but she could not sell it without permission from the trust. If she sold it, the proceeds would be divided according to the will. The parcel was the one Elaine had repeatedly described as worthless. It was not. A real estate listing inside Box 3 showed that a developer had contacted Dad about buying the land for a future warehouse project. The offer was dated 1 month before his death. The proposed price was nearly 4 times the value Elaine had claimed in court. I read the figure twice. Claire leaned over the table. "That land was part of the settlement, wasn't it?" "No, Elaine received the house and a fixed amount. The land was never mentioned." "Then why would he put it in the trust?" "Because he expected it to become valuable." The digital recorder was next. We charged it using a cable Victor found in the office. The file list contained 12 recordings. 11 were short. The 12th was 43 minutes long and dated 5 days before Dad died. I pressed play. At first, there was only the sound of footsteps and a door closing, then Dad's voice. "You don't get to rewrite alone because you're embarrassed by it," Mark answered. farther from the microphone. "I worked for you." "You were paid. I kept that business running." "You charged personal expenses to the company." "That was temporary." It was 3 years. There was a sharp sound as if someone had struck the desk. Then Elaine spoke. "Daniel, you're making this impossible." "No, I'm documenting it." "You are sick." "I may be sick. That does not make the numbers wrong." Mark's voice grew louder. "Who are you documenting it for? She doesn't even talk to you." I froze. Dad answered, "She will know what she needs to know." The recording continued for several minutes. They argued about the property, the loan, and the will. Elaine insisted that she had been promised the house outright. Dad said she had been promised a place to live, not permission to sell every asset he owned. Then Mark said something that changed the temperature in the room. "If you leave her everything, she'll take it and disappear." Dad replied, "That is her right." "She has no idea what any of this is worth. Then you should have treated her like a daughter instead of an account balance." There was silence. After that, the recording became muffled. We heard a chair scrape, Elaine crying, and Dad saying, "The documents are already filed. You cannot change them by pretending they do not exist." The final minute was clear. Mark said, "What if she never finds them?" Dad answered, "Then you will have to live with what you did." The recording ended. No one spoke. Victor had stopped pretending not to listen. He stood by the door with both hands on his clipboard. "Do you need me to call someone?" he asked. "Not yet," I said. My attorney had already sent instructions by email. She wanted the materials delivered to her office without alteration. She also wanted the storage company to preserve all access records and surveillance footage, if any remained. But the footage was not the only problem. The access log showed that Mark had entered the unit 4 times after Dad's death. The first entry occurred the day before the funeral. The last occurred 5 months later, shortly before the account was marked abandoned. Victor printed the log. Each entry listed Mark's access code. The first 3 visits lasted under 20 minutes. The fourth lasted 2 hours and 17 minutes. "Do you know what he removed?" I asked. "No," Victor said, "but we can estimate from the photographs taken during the original rental inspection." He pulled up an old file on his computer. The unit had been photographed when Dad rented it. The images showed a workbench, 2 filing cabinets, the wooden trunk, and several banker's boxes. The cabinet was gone. Most of the boxes were gone. The trunk had been left behind because it was locked. I thought about the note in Dad's letter. Ask for Teehee Ledger before trusting the story. Box 4 was missing. For the next 2 weeks, my attorney worked with an investigator to trace the missing property. The storage company cooperated after realizing its access procedures had been used to remove estate materials without authorization. We learned that Mark had rented a small office under a different business name. The lease began 3 days after his final visit to the unit. The investigator obtained photographs from the building manager. Mark had moved boxes into the office late at night. Then, unexpectedly, the office was emptied. Mark had closed the business and left town. His new address was unknown, but the investigator found a forwarding address connected to a vehicle registration in another state. My attorney sent a formal demand. The response arrived 9 days later. It was not from Mark, it was from Elaine. She claimed the boxes had been removed with her permission because she was the rightful beneficiary of Dad's personal papers. She said the recordings were private, the financial documents were irrelevant, and any attempt to reopen the case would constitute harassment. Attached was a scanned letter that appeared to be from Dad. It said, "I have given Elaine authority to collect my personal records." The signature looked close enough to fool someone who had not spent years seeing his handwriting. My attorney did not look fooled. She enlarged the scan and compared it with the signature on the original will. The letter had been printed using a font Dad never used. The signature was pasted into the document. The date was also wrong. It listed a day when Dad had been in the hospital. We sent the comparison to the court. That was the beginning of another hearing. This time, I did not feel the same panic. I knew where the documents were. I knew what had been removed. I knew there would be attempts to turn evidence into a family argument. Elaine appeared by video from a room with white walls and a bookshelf behind her. She looked older than I remembered. Her hair was shorter. Her voice had lost the sharp confidence it once carried. When the judge asked whether she had authorized Mark to remove the boxes, she said she had. When asked why she had not disclosed the storage unit during the original probate case, she said she did not know it existed. Those 2 answers could not both be true. The investigator testified about the access records. Victor testified about the original inventory and the condition of the unit. My attorney introduced Dad's letter, the recordings, the loan agreement, and the property documents. Elaine's attorney argued that the materials were private and should not be admitted. The judge asked, "Private from whom?" No one answered. The court ordered Elaine and Mark to produce all remaining estate property. It also directed the county recorder to place a temporary hold on the parcel of land. The developer's offer had expired, but the land was still worth considerably more than it had been when Dad signed the trust. Mark did not appear. His attorney claimed he was unavailable due to medical treatment. The judge gave him another date. He missed that one too. A warrant was not issued for failing to attend a civil hearing, but the court entered judgment against him for the undisclosed loan, the business charges, and the cost of recovering the records. The total was large enough to matter, though not large enough to erase what he had done. The more surprising result concerned Elaine. The land transfer was valid, but the conditions attached to it were also valid. She could remain there, but she could not sell it privately and keep the proceeds. The court ordered the property placed under the trust's control. Elaine had spent years telling people Dad had left her nothing. In reality, he had left her a home, a valuable parcel of land, and the right to live there without paying rent. She had risked all of it because she wanted control over assets he had specifically placed beyond her control. After the hearing, I drove to the property for the first time. It was an hour outside town, down a road lined with cottonwoods and abandoned farmhouses. The land looked ordinary. A weathered fence crossed the front and tall grass had swallowed the old driveway. Near the center stood a small house with peeling white paint. Elaine was waiting on the porch. I had not seen her in person since the courthouse years earlier. She did not invite me inside. "You got what you wanted," she said. "I'm not sure what you think that is." "The land, the records, the humiliation." "The court found the documents. You could have left it alone. You could have disclosed it." Her face tightened. For a while, neither of us spoke. Wind moved through the grass. Finally, she said, "Your father was afraid of being controlled. That is why he made all those rules." "No, he was afraid people would use confusion to control everyone else." She looked toward the road. "Mark said the storage unit was his." "Why?" "He said your father promised him the workshop." "Did he show you anything?" "No." "Then why did you believe him?" Her eyes filled, but I could not tell whether it was grief or anger. "Because he was there," she said. "You were not." That sentence landed harder than the accusations had. I had heard versions of it before, but never so plainly. Mark had been there when Dad was sick, when the workshop needed repairs, when Elaine needed someone to drive her to appointments. I had lived in another city. I had visited, called, and sent money when Dad refused to ask for it, but I had not been physically present every day. Elaine had mistaken proximity for ownership. Maybe Mark had too. "I know I wasn't there enough," I said, "but being there did not make either of you the owner of his decisions." She looked at me then. For 1 second, she seemed ready to apologize. Instead, she said, "He should have told us." "He tried." "No. He left instructions and expected everyone to obey them. That is not the same thing." "It is when they are his assets." She turned away. The court eventually sold the parcel through a supervised process. The proceeds were divided according to the trust. Elaine received the amount assigned to her. The rest went to the beneficiaries and toward Mark's outstanding obligations. The house itself was not demolished. A local nonprofit bought the property and converted it into transitional housing for families displaced by a factory closure. I learned that from a newspaper article, not from Elaine. The wooden trunk stayed with me. So did Box 4, eventually. It had been found in Mark's abandoned office, hidden behind a false wall panel. Inside were duplicate invoices and a notebook showing that he had planned to sell the workshop equipment before Dad died. The notebook contained dates, expected prices, and one line that read, "After funeral, move quickly." There was also a photograph. It showed Mark standing beside the workshop doors, holding a key ring. The date stamp placed it 2 days after Dad's death. On the back, in Elaine's handwriting, were the words, "We can finally fix this." That photograph was the last piece of evidence the court needed to reject Elaine's claim that she had known nothing. It was also the piece I never looked at again after the judgment, not because it was unclear, because it was. Years have passed since then. The people involved have scattered into separate lives. Mark's business records eventually led to tax investigations unrelated to my case. Elaine moved again. I heard through a lawyer that she was living with a relative and still believed the estate had treated her unfairly. I no longer feel the need to correct her. Some people do not want the truth. They want a version of events in which their choices were forced upon them. I keep the documents in a locked cabinet, not because I expect another lawsuit, but because I want the record to remain available if someone asks. Dad's letter is in a sleeve. The original recording is backed up in 3 places. The forged letter from Elaine is filed beside the court's ruling rejecting it. The key card from the envelope opens a small safe deposit box at a bank Dad used before I was born. That discovery came later. Inside the box were no diamonds, secret accounts, or dramatic final confession. There were photographs, my mother's wedding ring, a dried leaf pressed between 2 pages of a book, and a note addressed to me. Dad wrote that he had spent too much of his life believing preparation could prevent every kind of loss. It could not. Documents could protect property, but they could not make people decent. A recording could prove what was said, but it could not restore the years after trust was broken. Then he wrote one sentence that I keep returning to: "Do not confuse winning an argument with being free of it." I understood that only after the second hearing. The first case had been about whether I would accept their version. The second was about whether I would allow the truth to become another chain tying me to them. I chose the records, the court orders, and the boundary. Then I stopped answering messages that began with family. The inheritance changed my bank account for a while. The recovered property changed the final distribution. The documents changed my understanding of Dad. But the thing I use most often is simpler than any of that. When I update my own will, I do not leave instructions in a hidden folder and assume someone will find them. I tell the people named in it where the originals are. I give copies to the attorney. I label every account. I write down what I mean in language no one can turn into a convenient family understanding. And I tell my friends that a signature is not a gesture. It is a decision with a memory. The afternoon I finished organizing Dad's records, I carried the wooden trunk into my new house. The lid still had the same scratches. The initials were faded but visible. I placed it beneath the window in the spare room. Then I opened the final folder. There was no new revelation waiting inside, no hidden fortune, no secret child, no last-minute explanation that would make the years fit neatly together. Only copies of the signed documents, the ledger, and my father's handwriting in the margin of a page. Make sure she knows. He had written it beside my name. Not make sure she gets the money. Not make sure she wins. Make sure she knows. That was what he had left me. Not permission to punish them, not a reason to remain angry forever, a responsibility to know what happened and to refuse any story that required me to pretend I had not seen it. I closed the folder and turned off the light. For the first time, the trunk did not feel like evidence. It felt like something I could finally put down. Told you so. Told you.